Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I'm here with you every Sunday from 8 to 9 a.m. to bring you the information that you need as the landowner, as the gas right owner regarding natural gas development here in Pennsylvania. And as I hope you know, at the Clark Law Firm, I represent Pennsylvania landowners, property owners, gas right owners. I have not, and I'm going to tell you, I promise you, I will not represent oil and gas companies. Never have, never, ever will. And if you listen, look, these shows are up on the websites. Never have, never will, ever. Not who I am, not what I do. I love what I do, and I represent the Pennsylvania landowner and gas right owner. For such things as oil and gas lease negotiations, reviews, consultations. Been getting a lot more calls this year with oil and gas leasing that is occurring in Pennsylvania. We had a law last year, but we're seeing a lot more oil and gas leasing, especially in the north central area of Pennsylvania, but in other areas as well. So seeing more activity, that's good news. We're doing more and more too, more pipeline projects coming online. I think the last time I added it up, we're around doing agreements, pipeline right-of-way agreements with about, I think I might have cleared 70 different companies across Pennsylvania, giving you an idea of the experience and information out there. If you are trying to do a pipeline right-of-way agreement, a gas lease, or any other document, I hope you're not by yourself. But if you are, I'm going to tell you, in my opinion, you are making a tremendous mistake. Tremendous mistake. There's a really good chance that you're not maximizing the money that you can receive, and there's even a much better chance that you're not maximizing the language and protecting your property and protecting yourselves for future opportunities, that you're devaluing your property unnecessarily at times, that you're not understanding your leverage and you're not maximizing it. Very important. I'd love to hear from you because that's what I do. Represent people all the time. Love to hear from you. But if you don't call us, call someone. You need to have someone who understands your rights, your leverage, your ability to negotiate, who can inform you of your various options and making sure that you're doing the best for yourself, your family, your property, and future generations. I can't tell you enough where virtually every pipeline right-of-way agreement client who's ever called, it's resulted in a better agreement, and usually for more money, not always, but usually, and also in, I think, every case, improving the document itself, protecting you. And it scares me because I see more and more companies presenting in areas that haven't had a lot of this development yet, in areas that are starting to pick up, but this is the same for everywhere. But we're seeing companies presenting the unbelievably company-friendly agreements, sometimes with not even liability protection for the landowner, meaning you can be sued. Sometimes with no tax protection where, as a result of the agreement, you will have additional taxes depending upon the agreement, and you have no coverage there as well. These are basic items that you need protection on, but there are so many others. The key is getting information, getting someone who's there to help you, and not relying on the company landman who is not there to help you. They represent the company, not you, the landowner. Think about it. They are not at your table because you invited them. They're at your table because the company sent them to your table to get you to sign a document, a legal contract, most likely to be notarized, gives you red flags. Hey, this is serious stuff. I talk about, my father or grandfather selling hay bales out of the fields. This isn't a handshake. Hey, we're going to sell you 500 hay bales out of the field or out of the barn. That's not what this is. These are industrial contracts that can literally go for many, many decades, and most of them will, and can literally go over 100 years, over a century. We have to make sure we're doing a better job in protecting ourselves. And it's not happening in so many different areas. And companies are taking advantage of the kindness, as I said last week, the kindness of the landowners. They're taking advantage of the fact that landowners are not getting information or not protecting themselves. And they're going to continue to present these extremely beneficial agreements to the company because there are people signing them. Eventually, people will stop signing, or everyone who's going to sign these bad agreements will have signed them. Then the company will present better agreements. But as long as people are going to sign bad agreements, as long as people are not going to protect themselves, as long as people are going to mistakenly believe that the landman is working for them, not the company, mistakenly believe that, well, what is the company going to do? Are they going to present you very strong agreements? Are they going to give you more money? No. They're going to get the best agreement they can because people will sign it. So we need to do what? Stop signing bad agreements. Get help. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here every single Sunday on this station from 8 to 9 a.m. And you can always call the office. Any type of agreement, any breach, anything related to oil and gas, buying, selling, property, estates, anything related to oil and gas, breaches, anything. Give us a call, 570-307-0702. That's the Clark Law Firm, 570-307-0702. 0702. We need to make sure that all landowners, all gas right owners are signing the best possible agreements, and that if the company is breaching these agreements, that we hold them accountable. 570-307-0702. So today I want to talk about arbitration some. And I say this often, and because I know when people hear you say, oh, arbitration, well, geez, that has nothing to do with me. Let me turn off the station, move on, and get on with my day. Well, I understand. However, here's the difference, is that even if arbitration doesn't apply to you today, or you don't think it will apply to you in the future, there's a really good chance that it may come into play at some point for you as you go forward, and especially if you have any type of royalty issues, because virtually every lease, not every, but almost every lease in Pennsylvania has a mandatory arbitration provision. Why is that? Well, that's because that's what the company wants, and they put it into their form agreement. Remember, anytime that you're presented with an agreement as a lease agreement, the company who is trying to lease you gives you a form agreement, which is the first, say, 3-4 pages of the agreement, typically, sometimes 5, but generally 3-4 pages. That's the form lease. Ideally, the company wants you to just sign that, but they know that landowners have become somewhat more sophisticated, so they'll add an addendum to the agreement. Now, all an addendum is just additional pages with some additional terms. The addendum, the idea is for the landowner, the gas right owner, to negotiate to have terms added by way of an addendum to the original lease agreement. You want to negotiate to strengthen that by way of addendum terms. Something real simple. As a quick little example, the agreement may say the company can operate anywhere and everywhere on your property once you sign a lease. An addendum term could say, ideally, no operations of any kind on my property. You got to be very careful because companies have a lot of ways to write in loopholes, and I've routinely been seeing this year a certain company out there, happens to be Tioga County, But no, actually, in the Western, this company's active also in Western Pennsylvania, Southwestern Pennsylvania, but saying to people, oh, here's a no surface use agreement. We can't operate on your property. But when you read the language, that's just simply not true. Simply not true. So it's just an example of a very powerful term that a landowner thinks they have, when in reality, they don't have that language because there's a massive loophole the size of the Grand Canyon that allows the company literally to operate on the property, in my opinion, almost anywhere, but it really doesn't provide to the landowner what they think they're getting under the terms of that agreement. So my little side point there is that the company offers you the form. They've learned that landowners say, hey, I want to have an addendum. I read on the internet. I hear addendum. So often the company will present an addendum to you that has little to no value to you, meaning that it may track or copy what the company has to do anyway by law or DEP regulation. So you say, boy, I'm worried about my water, and the company gives you a water testing provision, which is probably less than or equal to what they're going to do, whether you have that language or not. So just because you have addendum terms added to the agreement doesn't mean that these terms actually give you anything of value. And we have to watch out for that. And I see that more and more, where landowner sends me and we do a review, consultation. They send me their lease. They send me the addendum. I read them. And I have these initials that we just say, hey, this is a throwaway provision, meaning that it has no value. It has no value. And I see a lot of throwaway provisions being offered to people in these newer leases, and we have to watch out for that. We have to protect you. We have to make sure that you understand that, yeah, you have 6 addendum terms, but they have no value to you, or very, very little value. So just another little, again, side point, that when you're negotiating addendum, you got to have quality addendum, not just have added addendum terms. And too many times, an addendum gives the impression that it's going to give you a certain value in a certain area, whether it be royalties, whether it be royalty without deduction, whether it be surface operation limitations, pipeline limitations. There's a lot of different ways that I'm seeing where companies are just blatantly giving the impression that you are getting, for example, a no surface lease, a lease with royalties without deductions. They'll even put headings in that regard in the addendum, but then when you read the language, and that's what matters, but they're hoping you stop at the heading. But when you read the language, you see, this language, although the heading says royalties without deductions, although the heading says no surface operations, the language says something different. And if you look in the lease and you'll find hidden in there, it'll say that headings, the introductory heading of the provision, of the clause, of the term, isn't relevant. It just is a heading just for notification purposes, and it's actually the words below the heading that really, really matter. And too many times, and I mean too many times, landowners are saying, oh, look, I have a royalty without deduction clause. It's right here in the heading. Oh, all this stuff underneath, that's pretty complicated to read, but I see right here it says royalty without deduction. All right, give me the pen. Let's go ahead and sign. Same thing. I don't want to have any operations on the surface of my property. Oh, here's the addendum term that says no surface operations. Sounds great. Okay. Well, yeah, there's a bunch of words underneath, and boy, they're pretty confusing. But look, one thing I can certainly understand is this heading that says no surface operations. You can't fall into that trap. Companies are very smart, in my opinion, and I feel this very strongly. There's traps set all over the place. And as we live and learn, we identify these traps and we learn how to adjust, how to address them. And if the worst case scenario, we learn to identify them and we're aware of them, and we factor in the fact that there are these traps and loopholes when we decide whether we're going to sign the gas lease, pipeline agreement, amendment, modification, whatever it may be. We identify it and we calculate that into how much money we want to ask for. Whether you want to sign now, whether you want to wait, whatever the case may be, it's critical to identify the traps and loopholes. And why do we need to get that assistance? Because the company who's drafting the documents, who's creating what I call the traps and loopholes, they're not going to tell you about those. Why would they? No, they want to give you a pen and sign, and we got to stop doing that. Okay, we're at the end of the first segment. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me every single Sunday right here in this station from 8 to 9 a.m. Been doing the show since 2010. So join us each week. Go check out pagasleaseattorney.com. Check out pipelineattorney.com. We'll have this radio show up and available tomorrow. There are many, many, many hours of radio shows available on the websites on all different topics. So go check them out. Listen at your leisure. If you can't join us every Sunday from 8 to 9, go check out the websites, pagasleaseattorney.com, pipelineattorney.com, and tune in to the websites at your leisure. And check out the information there. Whether you're looking for representation or information, go to pagasleaseattorney.com, go to pipelineattorney.com. You're looking for representation, you want to learn more about what we do, call 570-307-0702. I'm Doug Clark. I represent landowners. I'd love to help you. 570-307-0702. When I come back, I'm going to talk about arbitration, and I'm telling you, even if you don't think it applies to you, it's a great example, once again, as to how companies add language into documents that benefit them. Today, we're talking about arbitration. We could be talking about royalty and royalty calculation. We could be talking about a lot of things. It's the same principle, but today I'm going to explain to you, and I think you're going to find this very, very interesting, and it's a great example of how companies communicate to you about something is good for you, they want to do it for you, when shockingly, it's probably pretty darn good for them. I'll be right back. Stay tuned. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, join me every Sunday from 8 to 9 a.m. right here in this station. Also, been doing the show, like I said, since 2010. So go check out pagasleaseattorney.com. Check out pipelineattorney.com. Give us a call. Learn about what we do. I'm pretty confident if you have anything oil and gas related, there's a good chance we're going to be able to help you out. But give us a call. Learn about what we do. 570-307-0702. 570-307-0702. Love to hear from you and see if we can help you. Okay, I want to talk about arbitration. Now, again, this will make sense, so stick with me here. Arbitration. Here's something to think about. I talked earlier in the first part of the show, companies present you with a form agreement. That's agreement that they've printed, that's printed, pre-printed, it's drafted somewhere else, and they come to your door, they come to your house, they come to wherever, and they have that agreement in their hand, and they say, here, we want you to sign that agreement. Well, again, this agreement you had nothing to do with. This was just presented to you, and people sign them, which just amazes me, but unfortunately people do. And so it's presented to you. It's been drafted, again, by these extremely sophisticated companies with a very high-paid lawyers studying oil and gas law in Pennsylvania and across the country, drafting these agreements to take advantage as much as possible of the law and what rights and what things they're able to do. You'll see all the time, too. We can do such and such and such and such or anything else allowed by law. Well, you got to be careful. You got to negotiate. You got to enter into better agreements. We have to do that. Just ask all the people who just signed agreements, who've later on have had a lot of regret and said, boy, I wish we would have did something different. Again, these aren't doing deals to sell hay out of your field or out of the barn like my parents and grandparents did. These are industrial contracts that will last, in most cases, decades. In some cases, literally 50, 100 years or more. So these aren't, and I say that because I know from experience. I've seen my grandfather when I was a little boy shaking hands with the guy up the road, selling him hay out of the field or out of the barn. And same thing with my father to this day. But that's different. That's different. They're not dealing with Fortune 500 companies, top 250 companies. They're not. They're not dealing with multi-billion-dollar companies. They're dealing with another gentleman up the road. Companies know that. They know the mentality. They know what the mentality is of the Pennsylvania landowner in various areas of the state, and they use that mentality in order to make sure that they're going to get the best possible agreement. And again, there's nothing wrong with that, but we need to identify it. We need to understand it, and we need to do the best for you, There are so many times where people call, and I think, thank heavens you called. Because instead of getting $20,000 for this agreement, you're going to get $50,000. Instead of having no protections whatsoever in your agreement, you're going to be protected extremely well when we're done with this. And you're going to be really happy at the end of this process. That happens a lot. I cannot make any guarantees on any specific cases, but I can tell you it happens a lot. And that's why I get worried about people saying, well, I don't know. Call. Give us a call and learn about, if nothing else, a review and consultation. And then you go from there. They usually take an hour or two. And I say this not just because I say, call me, I want business. I'm saying it because in an hour or two, you can understand your rights, your leverage, the different directions you can go, and you can decide what is best for you. How people aren't doing that, or you don't do that, or you rely on the company landman. I don't know if there's a feeling out there at times, these lawyers, they're going to be expensive. They're going to try to take your money. No, that's not what I do. That's not what we're doing. We're here to help you. Yes, there's a service, and yes, people pay for the service, but learn about the service, if nothing else, and see if it's right for you. Because that call, and I can't promise you that call is going to do this for you, but I always go back. One gentleman, had he called me before he signed, it probably would have been less than an hour, and he would have known not to sign, and he probably could have negotiated to sign the document that he was presented at the time, and most likely received in excess of $5 million. Just one example. Again, that's an extreme example. I am not saying, give me a call and I'll get you $5 million. Not at all. But what I'm saying is that those things do happen. More likely, it is, we can bump this from 10,000 to 25, from 50,000 to 80, from 100 to who knows what. But you have to give the call. You have to learn your rights. There's no promises. But I'm telling you, that experience has shown that people who call and people who have reviews and consultations, I've done many of these. Many. I've never had a person at the end say, oh my God, was that worthless? I've had many people say, wow, I have so much more information than I ever thought. Thank you so much. I didn't realize that this was going to be such a valuable experience. I do hear that very often at the end of these calls. Go to the websites. And this, again, I'm not begging here for business. I'm begging for you to, I'm not begging, but I want you to call because I want you to learn your rights. I want you to understand what you can do, because I don't want people signing agreements for $20,000 when they could have got $40,000, or signing for $100 when you could have got $150,000. Let's not leave the money in the company's pockets. Let's put it into your pocket. Let's protect you. That's what we want to do. So my experience has been, these calls have been tremendously valuable to the landowner, to the gas right owner, and that's what we want to do. We want to raise the bar and get you that information. Apologize, I sound commercial there, but it's driving me crazy that people aren't calling and are signing these bad agreements, and I'm not sure what to do. We're trying to get the information out there. We really, really are, and we're going to continue. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me right here each and every Sunday, 8 to 9 a.m., and give us a call to learn more about what we do, see if we can help you. 570-307-0702. Okay, I'm getting to arbitration. Here we go. We're getting to arbitration. So I try not to get sidetracked. we have the form agreement presented by the company that has pre-printed language. Well, go look at yours, or pick it up later, go grab it now, or look at your offer you're presented, or remember this from when you are presented an offer. Go through the form agreement and see if there is an arbitration provision, meaning that if you get into a fight, a dispute, or any type of legal battle with the company, instead of going into the courthouse, you go through the arbitration process. Look at your agreement and see if the form agreement requires that any dispute that you have with the company will go into arbitration as opposed to going into the court system. And I'm going to tell you, you're going to find that in virtually all standard form leases, you're going to find a requirement, mandatory requirement for arbitration and not the courthouse. Mandatory arbitration written into the form gas lease by the company and their attorneys. Well, quiz. What does that tell you? It's in the form, drafted by the company, drafted by their attorneys. It's a form they've made without any input from you. A form that they've made without any input or discussion with you. If you were going to create a form agreement to present to another unrelated party, would you make that agreement more to your advantage or to the other side's advantage? Well, again, you're probably a nice person operating as an individual. Not saying that all these people aren't nice people in any way. I'm not saying that. What I'm saying is, though, this is a corporation. These are corporate entities. They're not human beings. It's a corporation whose job is to maximize profits, proceeds for the corporation. So it is their job. The attorney working for the corporation's job is to draft an agreement that is going to be the most beneficial to the company. Also one, hopefully, though, that they think they can get a landowner to sign, but it's going to be super beneficial to the company. Why wouldn't it be? Would the company hire a lawyer and say, hey, make a real even-handed, fair agreement to all sides here? No. Make an agreement that's going to work to our benefit, that's legal, that we can maximize profits and maximize future potential and future opportunities. That's what they're going to do. And look, you can't fault them for that. They should do that. So, given that background, we're talking about an arbitration provision that is located in the form of the agreement, the form lease presented to you. That tells us it's beneficial to the company and probably not so beneficial to you. Otherwise, why would a company put arbitration in every single company just about? I don't know when the last time I saw an agreement recently in the last year or two that didn't have mandatory arbitration. And going back, they almost all do as well. But why are the companies doing that? Well, again, because they think it's to their advantage. If they didn't, they wouldn't put it in there. And what do they do to the landowner? If you question it, they say, well, geez, that's really good for you. That arbitration clause, that's really good for you as the landowner because it's faster, it's quicker, it's less expensive. It's really good for you. So my response would be, well, I know that it's really good for me, but I'm just one of those guys where, even though it's good for me, I don't even want it. If it's so good for me, then you as a company won't mind if we remove the arbitration provision from the lease agreement. If it's good for me, if you're going to tell me it's good for me, then you would never have an objection to having that language removed because that would be to your benefit as a company. So say that to them. Say that to them and see what they say. Say that to them and see what they say. See if they say, oh, wow, great. Well, geez, that's great news because we'll gladly get rid of that. We put that in just to protect you. So that's great news. Well, I will virtually guarantee, I can't guarantee, but I can virtually guarantee you're not going to hear that. You're not going to hear it. They'll probably tell you it's to your advantage. You ask to get rid of it, they'll come up with some other reason why they need to have it in there. And it's just watch it. Watch those verbal gymnastics if you ask those questions. Watch it. First say, why is this arbitration in there? They'll tell you how it's good for you. And then you say, I'd like it out. And then see what they do. I'm going to explain what the problems are with arbitration here in the next segment. And these problems are substantial, in my opinion. As a general rule across the board, generally speaking, we want arbitration gone. Companies want it in. We want it gone. And I'm going to explain why that's the case as a general rule when we get back after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me every single Sunday, 8 to 9 a.m. right here in this station. And remember, Northeastern Pennsylvania, doing so much more with pipelines. We're getting lease modifications. Very important. If you are given an amendment modification to your lease, do not simply sign it. I would recommend give us a call, 570-307-0702. Had a couple cases recently, big cases, I believe, because the company's got themselves in a pinch and now wants you to amend or modify your lease. If you are just signing amendments and modifications, my opinion, strongly, you are making a big mistake. At least do a review and consultation and learn what's going on, identify why you're being asked and what you should be doing about it and what your options are and what your rights are. Give us a call, 570-307-0702. Don't just sign. Call 570-307-0702. Stay tuned. I'll be right back after yet another very important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can join me each week right here at this time on this station. I'm going to jump right into it here because I had a lot to talk about with these arbitration provisions. So again, arbitration is virtually always included in the form agreement presented by the gas company, especially in the form leases. That should tell you why is that in there. Here's another thing. Go look at those. You ever look at those complicated, and no one reads them, your contract, say, with your credit card company or your bank. Those contracts, virtually all, include mandatory arbitration. Any of these contracts with these big companies, for the most part, you'll find include mandatory arbitration. Why is that? Because it benefits you, the little guy? No, it doesn't. Or they wouldn't include it. And the law across the country has been evolving more and more so that arbitration is beneficial to big companies. So big companies love to have arbitration in their agreements when they're dealing with the little guy. So what does that tell us? As little guys, we need to remove that if at all possible. We need to identify why is the company doing this. Ask them. And what they will tell you is, well, we're doing that. This is a good thing for you because it's quicker. It'll take less time. Well, quicker, take less time. It will cost less money. This is really good for you. We say, okay, fine. It's really good for me. I'm going to go ahead and let it go then. I don't want it. I know it's good for me, but I've elected that I don't want it. And then see what the company says. They're not going to want to remove it because they're going to tell you it's good for you, but the reality is it's good for them. It's good for them. So let's talk about it. Why is it good for them? You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Call us anytime. Learn what we do, 570-307-0702. Why is arbitration good for the company? Well, there's many, many reasons. So here's some things that you'll typically hear when they say, okay, we want to have this arbitration. Like I said, they're going to tell you it's better because it's faster and it's simpler and it'll be cheaper. Well, the reality is, first off, all of those things may not be true. All of them may not be true. And in fact, as we go forward, if I have my choice, I would not do virtually never would I have a client or want to have a client enter into an agreement that included a mandatory arbitration provision. Very rarely, in my opinion, not specific advice for anyone, generally speaking, very rarely do I ever think that it is to a client's advantage to have an arbitration provision in their agreement. There are times, but very rarely, because the reality is the company, again, it's in the form of their agreement. They want arbitration. Generally speaking, we do not. Why don't we want arbitration? Isn't it quicker? Well, no, it may not be quicker. Sometimes it is, sometimes it isn't, but it may not be. Also, well, why do the companies want this? Why do the companies want it? Well, there's many reasons that the companies prefer it. In arbitration, well, let me back up. So if you go into court and say you were going to sue a gas company, there's a decent chance that your lawsuit may be on a contingency fee basis, meaning that you don't have to pay your lawyer unless you win and you have some sort of financial reward or gain or benefit at the end of the case. So you wouldn't have to pay your attorney any money in order to advance the case or to prosecute the case. But if you go to arbitration, you as the landowner are going to have to pay, or your attorney, if there's a contingency fee, but is going to have to pay for the filing fees, which are typically much higher than filing in a courtroom to initiate the case. But you have to pay for the arbitrator's fees. The arbitrator is the person or persons who are going to be hearing your case. And it is not unusual for a well-known arbitrator to be charging anywhere, say $3,000, $4,000, or $5,000 a day, and you're responsible for half of that money. Think about if you have 3 arbitrators, 3. Let's say they all charge $5,000 a day, and if you have 10 days, that's $15,000 per day times 10. That's $150,000. That's a lot of money, and that's going to deter many landowners, most landowners and lawyers from bringing lawsuits against the company. Company says, yeah, we got a lot of money. We will beat you down with our money. We will say, okay, yeah, we'll go to arbitration and we'll pay arbitration fees, but you have to pay them too. And so you could lose a case and be out a whole lot of money in arbitration fees. That's a big problem for you, the landowner. Big problem. Arbitration provisions, in my opinion, deter many lawsuits that are reasonable, legitimate to be brought against companies because the fear that it's going to cost too much money in the event that I lose. That's a problem. Companies know that. So they may be able to tamp down or discourage hundreds and hundreds and hundreds of lawsuits because of arbitration provisions. So that's just one example. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Here's another example. Arbitration. Who's going to hear the arbitration? Well, it's going to be lawyers, or maybe an ex-judge, somebody like that. Not a jury, not a jury of your peers, but a lawyer, a judge, someone of that nature. Now, you may have to go to a certain arbitration, things called AAA arbitration. I won't go too far into the weeds here, but you may go through a certain service or agency, and most of the people, so they have lists of arbitrators. There's a really good chance let me back it up. Let's just say hypothetically, maybe that these arbitrators might be more inclined to towards big business as opposed to the small landowner. Maybe not, but maybe. You get a bad arbitrator. Say you have one arbitrator only. You get a bad arbitrator. What are you going to do? If the arbitrator is favoring the company, and that's the way they tend to look at things, you then go, you spend the money to pay for arbitration, you lose, and company says, oh, it's quick. Well, yeah, losing quick isn't so great because you still have to pay your arbitration fees, and then you say, well, geez, I really got a bad ruling from this arbitrator. It was a really bad ruling. We were right and the arbitrator totally found the other way and ruled in favor of the company. If you are in the court system and that occurs and you lose at trial, what can you do? Or you get bad rulings from the judge, what can you do? You can appeal and go to the next level and have that issue or the case reheard by the appellate court, who could say, you know what, the trial judge made an error here or made errors. We're going to send it back. And so you get a second bite of the apple because another group of judges looked at your case and found an error. If you go to arbitration and you get a bad ruling and there's a final ruling, you are done. You can't appeal. It's over. It's over. So it's not necessarily a good thing to have a speedy result if the result is bad. But I say speedy result. There's no guarantee that you're going to have a speedy result. I can tell you I was involved in an arbitration that took a very, very long time. So don't get caught up on, it's going to be fast, because first off, it may not be. And secondly, if it is fast, it may be a fast, bad result that you cannot appeal or do anything about when you know that legally you feel strongly, as does your lawyer, that the arbitrator ruled inappropriately against you and against the law. But again, there's nothing you can do about it. But if you were in trial, or you were in a trial court, or you were in a court system, you can appeal and you have a remedy. And I'll tell you, I reviewed a case the other day where 2 different times the same case went up on appeal, oil and gas case involving a company, and both times the appellate court ruled the opposite way of the trial court. But if you were in arbitration, you'd never have that chance to go up and have your case appealed. And again, too, arbitrators are not jurors. Jury, wouldn't you want to have your case, wherever you are, be in Susquehanna, Bradford, Tioga, Potter, Wyoming, anywhere in southwestern Pennsylvania, Washington, Green, anywhere you're at, wouldn't you rather have your case heard by a jury of your peers, by other landowners in your area, by people who represent your community? Or do you want it heard by a former lawyer who worked at a huge law firm that now their firm represents oil and gas companies? Just an example. Who would you rather have hear your case? Obviously, we know who. Who would a company rather have hear the case? A jury of landowners of your peers? Or by a judge, a lawyer who maybe is much more inclined, maybe, to be favorable towards big business and not so much the landowner? You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station for All Things Marcellus. Okay, jury trial, enormously important. The company doesn't want your case going to a jury. So here's another point. What about if you go and you win? Say you have a royalty issue and you go into arbitration, and the arbitrator finds in your favor and says, with your lease language, the company is not allowed to take royalty deductions. Let's give that example. Now, please pay close attention, because this is pretty interesting. Most people don't understand this or aren't aware of this. So you have a lease that you think says no deductions from your royalties for costs such as gathering and transportation. Company's taking those deductions. You say, I want to sue this company. Again, you'd love to go to a jury, but you have mandatory arbitration. So you go to arbitration. Fast forward. Wonderful result. Arbitrator rules completely in your favor and says, you company under this lease language are not allowed to take deductions. And therefore, I award the plaintiff complete victory. Well, that's pretty good, right? Well, and also what's good there is the company can't appeal. So all that's good. That can happen. A lot of bad things can happen. I would rather have that case in front of a jury, in front of an arbitrator anytime. But here's the next step. That arbitrator's decision carries no weight whatsoever in any other cases. What I mean, there's no what they call precedential value, that the arbitrator awards in your favor. However, that is a private arbitration. it doesn't get written up so that the next guy who goes into arbitration, so say your neighbor has the same lease, same case, same company. He also has mandatory arbitration. He goes to arbitration to fight his case. And he said, this is after you won your case. So he says, okay, company, I'm going to win because my neighbor John here, he just won on the same case. And you say, I'm just going to take his case, show this arbitrator what the other arbitrator did, and I'm going to win because there's precedent for me because the other arbitrator ruled exactly in the same way in my favor for my neighbor. Doesn't work that way. That arbitrator's decision is irrelevant to the next case. So as a company, we talk about bites of the apple. Each and every, say there's 5,000 people in the county that have the same lease, and the first one goes and the arbitrator rules in favor of the plaintiff. Well, the company says, hey, that's okay, whatever, that's fine, it's not fine, it's what it is. Every case from there on out, we're going to take to arbitration, and we'll win some, we'll lose some. But I'll tell you this, as a company, if Mr. Smith, the arbitrator, rules in favor of the plaintiff on that issue of taking deductions, ask yourself this, guys. Will Mr. Smith ever be approved by the company for any future arbitrations on that issue? No, they won't. They won't. So the companies will have a book on every single arbitrator, and that arbitrator has ever ruled in favor of a landowner, and the company has input on arbitration panel who's going to be approved, and they almost always will. You're never going to get that guy again. You're never going to get the guy who ruled in favor of the landowner again because the company knows they rule in favor of the landowner. Also, you can't take that Mr. Smith's arbitrator's decision and use it in the future and say, hey, this issue has been settled. No, you can't because there's no precedential value. If you were in a court system, it would be totally different. I'll talk about that after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Stay tuned. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here at this time on this station each and every week, and I hope you do. Going to jump into it. We have a short segment here. Arbitration. Again, I would try to remove it virtually in all agreements as a general rule, but not specific advice. We talked about, I'll just tick off some reasons here. The company does not want to go to a jury trial as a general rule so that your case is not heard by a jury of your peers. They want it heard by ex-judges and lawyers where they have input and from people who may be more slanted to their side of thinking than yours. They do not want to have any precedential value, meaning if a bad ruling goes against them, they don't want others to be able to use that in the future. So they say, let's go to arbitration where there is no precedential value. Very important for the company because think about it. If they went to court and they lost and it goes to the Pennsylvania Supreme Court and the Pennsylvania Supreme Court says you cannot take deductions under this lease language from landowners' royalties, then that's precedent and now the companies are stuck. But each and every time that they may lose an individual arbitration case, that does not set precedent. And so each and every time you as a landowner want to fight the company on these issues, there's nothing, even though your neighbor may have won the same point, that doesn't help you at all in your arbitration. Very valuable for the company. Class actions. Very difficult, if not impossible, very difficult to bring any type of class action and sustain it against the company. So some may argue it's a license to steal. Imagine this, if you interpreted a royalty provision that had a negative impact on people, let's just say hypothetically, an average of $2,000 a year, and say that affected 10,000 people. Well, 2,000 times 10,000, that equals a whopping $20 million. So, again, this is hypothetical, but by an illustration, to illustrate the point. If a company was able to interpret lease language that was questionable, and the net result was 10,000 lessors, landowners, were receiving, on average, $2,000 less per year. $2,000 less for 10,000 people equals $20 million. You as an individual landowner are probably not going to sue the company for what you see as shortchanging you for $2,000 in a given year, because it's going to just simply cost too much and it's going to be too burdensome to bring. So think about it. If you're a company and you know that and you interpret the language a certain way, then you may have a $20 million windfall because no one's suing you, because it's just too hard to sue, because it's just a little bit of money, but it's from a lot of people. That is the reason of class actions. That's what class actions are about, to try to fight against. So that, again, I don't want to make this specific. We'll just say, so a credit card company can't steal $20 from everybody each and every year, because now if you can bring these as a class on behalf of the 10,000 or 50,000 or however many people, even though per person the damages aren't high, as a combined group, the damages are very high. So, shocking news alert, companies don't want class actions. They want to say class actions are bad, bad, bad. Class actions can be the only tool to assist and protect the landowner in our examples, or the consumer, whatever the case may be, because it's simply too small of amount of money for each individual. So you have to bring it as a group. Bringing class actions as an arbitration, my opinion, next to, in light of the recent laws and things like that have changed and court decisions, next to impossible. So company, they don't want class actions. They want arbitration. They want you to go individually. If you lose, you lose. They're never going to choose that arbitrator again. They will fight to keep that arbitrator out, and they will just keep shopping around for arbitrators that rule in their favor, and so on and so on. Now, another thing, I just wanted to point to this one part before I run out of time. I have here an arbitration clause from a company presented in their agreement saying that the arbitrator must have substantial experience in oil and gas industry with respect to natural gas drilling and operations in the Commonwealth state where the arbitration occurs. I mean, in Pennsylvania. Let me give you a clue. That means that probably that arbitrator is going to have spent a career working for the oil and gas company. So which way do you think they're going to be leaning? There are tricks everywhere. We need to identify them, and we need to protect ourselves. And as I started out, this is an area arbitration is just an example. There are many other ways in which we could use a similar analysis for other terms that companies add to their form lease agreements. Arbitration is something, generally speaking, we should be fighting to remove from these agreements. Also, the company, if they know they're going to arbitration and a bad ruling cannot hurt them in the future, they're much more inclined to fight you, not to try to settle, not to try to work something out. That's very important. If you were going into the courtroom, remember also, you're going to have media. There's going to be newspapers, maybe television stations. Companies don't want that. They don't want to have a negative ruling that's going to impact them forever. So what do? Arbitration. Identify it, understand it, try to get rid of it. Companies are a lot more likely to settle with you or resolve a dispute if they're afraid the court may set precedent that will be used against them for many years into the future. Very, very powerful. Remember, too, Northeastern Pennsylvania, all across Pennsylvania, give us a call. A lot going on nowadays. Don't sign without getting assistance. Give us a call, Doug Clark, 570-307-0702. And remember, we need to stop signing bad agreements, and we cannot forget that the gas and pipeline company landman works for the gas and pipeline company, not you, the landowner. Give us a call, 570-307-0702, and tune in each week at this time on this station. Have a great, great week, everyone.